My name is Michael Rehm. I'm an attorney. This video today is in regards to personal injury cases, specifically auto accident cases, truck, motorcycle, automobile accident cases, or more specifically what they refer to as motor vehicle negligence. Anytime you hear of an auto accident case or a personal injury matter related to an auto accident case, what it really is a negligence action, and specifically a motor vehicle negligence action. At least that's one of the causes of action that will be brought. This is not a, don't take this as legal advice. The laws can change. If you're watching this video, the law could be different than the date that I made this video. My understanding of the law could differ than other attorneys. So don't take this video as legal advice. Take it more on just kind of a guide for the gist of the law. That's what I'm attempting to do for those of you that might be going through this and not quite understanding how the law applies to your case. This is meant to help in that regard. It's not an outcome of any kind of result. It doesn't constitute any kind of an attorney-client relationship simply because you're watching this video. It's just an attempt to help out those that are going through this that might not understand the law. So, the law, auto accident cases, personal injury matters, is really negligence. Negligence, specifically motor vehicle negligence. So what is negligence? The legal definition of negligence, one of them at least, is a breach of a legal duty owed to the person injured. And the breach was the legal cause of the injuries. Person A owes a legal duty to person B. Person A breached the legal duty to person B. Because of that breach, person B gets injured. That's basically what negligence is. And that applies in more than just the motor vehicle context, but today is going to be about motor vehicles. So, in the motor vehicle negligence context, there's certain elements you have to show in order to properly prove a negligence case, motor vehicle negligence case. You have to show foreseeability. You have to show a duty, a legal duty. You have to show a breach of that duty. You have to show causation, and you have to show damages. All five of those elements have to be properly pled and proved in court. So first you look at what is foreseeability. Really, foreseeability and duty, in a sense, go hand in hand. So let me just start with duty, actually. That'll probably make it easier. What is the duty of care in an auto accident case? Well, the motorists in general, must exercise the degree of care and caution that an ordinary, careful, and prudent person acting under the same or similar circumstances would exercise for the safety of others. So all motorists have a duty of care. That duty of care is that they act, they show that the normal, what an ordinary or reasonable person would show under same or similar circumstances. That's it. What would an ordinary, reasonably prudent person, how would they drive under the same or similar circumstances? That's your duty. That's your duty of care. Now, who is the duty of care to? Well, that's where foreseeability comes into. The duty of care is to all persons that are foreseeably endangered by the conduct. So, in the motor vehicle context, that would apply to a whole list of individuals, people in the other cars, people walking in the crosswalk, passengers in your car, and so forth. So the duty of care for a motorist is to exercise the degree of care and caution an ordinary, carefully and prudent person would exercise under those circumstances, and that duty applies to everyone that is reasonably foreseeable by that conduct. Under the duty element, couple things you should know. Compliance with the law is not conclusive. Just because you're complying with the written law doesn't necessarily mean that you're not negligent. There's several different cases that deal with that. I know it seems counterintuitive, but just because you're going the right speed limit doesn't mean that it's not too fast for the circumstances or too slow for the circumstances, depending on what the circumstances are. Minors, those under 18, they are held to the same duty of care, this duty right here, as an adult. If the motorist has knowledge that there's small children present in the area, they have to have a greater degree of care. They have to act more cautious than normal because small children run into the street and so forth. And there's a very old case that deals with that. There's a couple of cases that specifically deal with the small children issue. The owner of the vehicle also owes a duty. And that is, and a lot of times you'll see this in the truck accident cases, the big rig cases, for maintenance. They owe a duty of care of maintenance. Now, what is the duty of care for maintenance? The duty of care for an owner is that the owner must exercise care that an ordinary and prudent person would exercise to maintain their vehicle in a reasonably safe condition. So if you own a vehicle, you have to take care of it as to what is reasonably expected to make sure your vehicle is safe. One real important thing about that is what they call non-delegable duty. So you can't contract out of it. If you own the vehicle and someone else is driving it, and an accident occurs because of a mechanical defect in the vehicle, it's your fault as well. Whether the driver should have known about it is a separate issue. They could be liable as well, but the owner cannot contract out of it. Enterprise cannot rent me a car and I'm liable for a mechanical defect in the vehicle simply because I signed a contract saying I am. You can't contract out of that for what they say is public policy reasons, and it's sound public policy. So that's a little bit about duty. It's pretty straightforward. A motorist must exercise an ordinary, careful, and prudent standard of care to everyone foreseeably possible that a reasonable person would foresee. Element 3 is what they refer to as a breach of the duty. Whether it's an act or an omission, the motorist breached their duty. And that, whether or not the motorist breached their duty, is going to be based on the facts of the individual case. So if someone is driving a vehicle and they crash into the car ahead of them at a red light, and the car at the red light had been there for quite a period of time and it was pretty clear in front of them, more than likely that would be considered a breach of the duty. Now, if the same individual was driving the car and had some sort of a medical condition arise, they passed out for some reason and lost control of the vehicle, then it's very arguable they did not breach the legal duty. So it's a pretty simple, straightforward thing, but for what it's worth, the third element is related to the second element, of course, and that's, was there a breach of the duty? We know what the duty is. We know who the duty extends to because of foreseeability. Now, did the motorist breach that duty? And then element 4 is what they refer to as causation. There must be a connection between the negligent act and the injury. Now, if, for example, hypothetical, same scenario, car's parked at a red light, car and the other driver drives and crashes into the back of it. If someone in the house across the street hears a noise and comes running outside and trips over a broomstick that they had lying out, and they get injured, it's very, very arguable. You have a very strong argument that the individual that caused the accident did not cause that individual's injuries. The causation is not there. Sure, they were negligent, they caused the accident, but they didn't cause the individual who ran outside and tripped over the brooms injuries. So there has to be a connection between the negligent act and the injuries. For the most part, especially in a motor vehicle case, there obviously will be. If an individual breaches a duty and gets in an automobile accident, normally the accident will be the cause of the injuries. And when I say cause, I mean legal cause. Now, what is a legal cause? Does that mean that it's the only cause of the injuries? No. It means that the breach of the duty must be a substantial factor in causing the injuries. So it doesn't have to be the only cause of the injuries. It just has to be a substantial factor in the injuries coming about. And then finally, you have damages. There has to be damages, and that's pretty straightforward, whether it's medical bills, past, future, lost wages, emotional distress, whatever the damages may be, you have to show there was some sort of damages in order to properly prove a motor vehicle negligence case. Like I said, for the most part it's pretty self-explanatory, but when you're actually in court, the details matter, to say the least. So the motorist has a duty to everyone reasonably foreseeable, a breach of that duty, and the breach of that duty actually was a substantial factor in causing the injuries, and the injuries led to damages. That is a motor vehicle negligence case, and that's the way these cases are handled in court. My name is Michael Rehm. These are the way these cases are also negotiated as well. You have to have all these elements if you expect to get any kind of a judgment or settlement in your favor. My name is Michael Rehm. 1-800-978-0754. I offer free consultations. If you have any questions or any follow-up, or if I didn't make anything clear, please feel free to contact me. I wish you luck.